Hey, welcome back to Sovereign Citizen Chronicles. Today we have Judge Victoria Shackelford going up against a sovereign citizen named Arnold Chavez. All right, there's a couple of credit card companies that's going after Arnold Chavez for not making his payments, and he feel like he can stand on sovereign citizen. I don't know, a sovereign citizen defense. All right, so let's see how this works out for Mr. Chavez.
All right, this is 2301408 JP Morgan Chase Bank versus Arnold Chavez appearances.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so last time we were here, the parties appeared and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just said, I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
Okay. So, Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, you know, I've been researching the law and, you know, the powers of the banks, and it's more of a accuracy of the actual accounting that I'm trying to make sure, and, you know, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, you know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, I mean, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. I mean, that was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You know, you say you gave them 10 days to send it to me. They didn't send it to me. I just got an email this morning.
You're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those
so,
are the questions.
Okay, my defense is I am the lender, and they borrowed from me.
What did they borrow from you?
My personal security, which I'm entitled to rights to.
No, I'm not buying that. No. Listen to me. Listen.
It's not about. I have it. I'm going by the law, Your Honor. I'm not just making up anything.
No, you're not going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card, and you didn't pay on the card. They don't owe you anything.
So so when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time, and I was going to file one, but this hearing was a little bit too early. The motion would have had to been filed the next day, so I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. One second here. I have them.
No, wait a minute. December 19th.
Okay. It's gonna have to be January 9th.
Okay,
My clerk's indicating.
I will get that out right away. I had it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set. All right, and I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and it was working in my area. And I have proof of. I talked to them in the chat. They confirmed it, and I have they gave me a bill credit for the inconvenience, so that's why I wasn't able to attend because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
Okay. All right. Here's what we're going to do. I'm setting a date. So what do we need discovery on this? Mr. Goethals, so this is a credit card bill?
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands?
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29, will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set. All right, we're all set. Thank you, Mr. Arnold. Mr. Arnold, I have ruled against you. I am allowed to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Thank you, Your Honor.
All right, that's the conclusion of the proceeding. Unfortunately, it did not work out for Mr. Chavez. The Judge Shackelford made her ruling. She wasn't playing no games with him, and it looks like he's going to have to own up to those debts. All right, so I just want to thank you for watching. Definitely like, subscribe, and hit that notification bell so you get notified when I upload more videos. Also, leave a comment and let me know what you think about the video and the channel.